Court is now open. You may be seated.
Good morning.
SJC-11298, Commonwealth versus Ortiz.
Thank you.
Good morning. If it please the court, Robert Chekatoff for the defendant appellant, Louis Ortiz. I always thought that a stipulation was evidence, but when I went to find some case that said that, I had a very, very hard time. And the closest I could come was a First Circuit case, which was reversed on other grounds, and it's cited in my brief. And that's a 2-to-1 decision, where the First Circuit says that it's generally accepted and thought that a stipulation is evidence that has to be presented to the jury before the close of the evidence.
But by definition, a stipulation is an agreement between the parties as to an issue?
Yes, Your Honor.
Would it not matter what the stipulation is about? I mean, there are stipulations, as you know, which say that we agree that if this person were to testify, she would testify as follows. That, of course, would have to be presented to the jury. But there's also ones which essentially say we agree that an element is proven. And is that not a little bit different in that it essentially means the jury need not consider it and therefore need not be presented to the jury because the jury is not going to be asked to decide it?
I see that distinction, and I can't deny that that is a distinction. But I still think it's a piece of evidence that the jury has to be presented with in order to reach its conclusion. Now, in this case, for instance, this is raised by the motion for required finding and not guilty.
Was that argued, though?
No. But our case law is that if you make a motion for required finding and not guilty, it's preserved. This court has never said you didn't make that particular argument, but we agree with that particular argument, but we're not going to enter a not guilty verdict.
Isn't there, just on that point, I thought that the law was, or the case law was that if you just generally moved for a required finding of not guilty, some specific issue may not be preserved. I'm thinking about some of the sort of mid-'90s joint venture cases, like Green, or I'm not sure, but I thought that's not so.
Of course, and this court has pointed it out to me on numerous occasions, I am often wrong, but it's my
But never uncertain.
But never, well, rarely uncertain. But it's my view, this is in the back of my head, I didn't research this for this argument, that this court has never said that we agree that if you had argued the right issue for a required finding of not guilty, you would have been entitled to it,
Okay.
but we're not going to give it to you because you didn't argue it. So in this case, it's raised in that context. And the test is, must a reasonable jury conclude as a matter of law that the evidence is insufficient? And how can something that's not in front of the jury be in the equation?
Well, they've been told they don't have to worry about it.
They weren't told that until until instructions.
Well, that's what I mean. So when it went to the jury, they
Right.
didn't think they had to consider it.
But it's the evidence when the government rests, the evidence must be sufficient for a reasonable juror to conclude that the defendant is guilty. Otherwise, you're entitled to required finding and not guilty. And how can something that's not in front of the jury enter into that equation?
You mean even if it is a stipulated fact, the effect of which is a judge must instruct the jury, you, the jury, have a stipulation of fact, you must accept that. You're saying that even in those circumstances, it still has to be.
It has to be, the jury has to be informed of it.
So let me ask you a question. You know, like, under Rule 11, if it had been reduced to writing at, you know, the pretrial conference report and the defendant signed it and everything, but it was done the same way, the judge didn't do anything about it until jury instruction time, what's the result?
I say I still win on this issue because it's an issue of evidence. I lose on my second issue, which is the Mass Rule of Criminal Procedure Rule 11 issue, but I win on this issue because it's a matter of evidence that has to be presented to the jury. I mean, what we're really talking about in reality is a prosecutor who forgets to do something. That's what we're talking about. And the question is, should the judge bail him or her out at the instruction stage of the case? And
Sounds to me we're talking a little bit more about a game. I mean, the parties have agreed. The judge has understood. The parties have agreed that this is not that this is an agreed upon fact. I mean, this is not a game.
No, it's not a game, and that's why I think that the judge should not weigh in at the end of the case. I mean, we're entitled to the most impartial judge possible. I think that that's out in the front lobby, too, and it's a Massachusetts constitutional concept. I think we don't want the judges weighing in on one side or the other.
Well, are you saying that parties can stipulate to something and then afterwards, if it's not presented to a jury, the stipulation has no value, no meaning?
I'm saying that.
You're saying that?
And this is a simple thing for a prosecutor to do. I don't think it's for the judge to bail him out.
Could you tell us a little bit about how the stipulation, what circumstances the stipulation was made in? You know, and was it made at the first trial as well?
No. Well, there was a stipulation at the first trial, but it was a different stipulation.
Not as to this element.
No, it was as to this element, but the stipulation at the first trial was, I will not object to the certificate of analysis coming in. That's what the lawyer agreed to. At this trial, the judge said to him prior to impanelment, and this is a tape-recorded trial, so I can't picture this exactly. I don't know where this conversation is taking place. But he says to him, except it's in the courtroom, he says to him prior to impanelment, are you willing to stipulate that it's cocaine? And he says yes.
Is the defendant there?
Probably, but I can't tell. I mean, I'm sure he's in the courtroom, but I can't tell from listening to the tape recording where he is.
But you have no affidavit from your client saying, I was shocked to learn that my attorney...
No, I do not, Your Honor, and this is a direct appeal. I didn't raise this as a motion for new trial issue, trying to expand the record as it exists.
Now,
I take the position... I apologize.
I'm sorry, go ahead.
I take the position that a defendant is... You know, the first cases that this Court ever reversed for ineffective assistance of a counsel, the trial itself, were Westmoreland and Street. And both of those were tried by the same defense lawyer. Both of those were tried in Suffolk County. And in both of those, the lawyer said in a closing argument, I abandoned my insanity defense, in effect. One of the defendants stood up and objected to his lawyer's abandoning his defense. The other one didn't, but it made no difference to this Court. Is it realistic to expect defendants to object to things that their lawyers are saying? Is that their role in the courtroom when they're represented? So to me, whether he objected or he didn't object it is not really the issue. The issue
I mean, it strikes me that if you have an issue at all, it's that counsel was ineffective in some way. The counsel was ineffective for stipulating to this. Isn't that your issue?
No, I don't think so. I have two issues. One is that the prosecutor basically failed to get it into evidence, even though he had the agreement.
I guess one of the things I think we need to sort out is it, as you said, as you began, is this a point of evidence, or is it the withdrawal of an issue from the jury's consideration?
I think that's fair.
What do you say about that?
I think it's evidence. I think it's always been considered evidence.
Well, let me put it to you a different way. Why isn't it the withdrawal of an issue from consideration in the case? Turning a 4-issue case into a 3-issue case?
Because all you're saying is, I'm not going to require you to produce evidence on this issue. I've agreed you can put in this writing or this oral representation, but it's still something that the jury theoretically has to find, even if the judge instructs them that this issue is stipulated by the parties and therefore it's uncontroverted. the jury still has to find it. It's still an element of the crime. And, okay.
Could a defense lawyer stipulate to the fact that it's cocaine and then argue that, members of the jury, all you have before you is a stipulation, you don't have any evidence, you just have that stipulation, that should not be viewed as enough by you?
Well, to the extent that you can argue that you don't have to follow the instructions, you're free to decide the case, which is the law. The jury has the power. I don't think you can argue that, though. So
That's a little bit different. That says that you can ignore what the judge says to be the law.
Right.
Stipulation is not a matter of law. It's an agreement by counsel that certain things are true, and therefore. But
Not
is it your view that the mere fact that you enter into a stipulation means that the jury still is free to reject it, and that it's a matter still before them?
I believe it's a matter still before them, but I don't believe they're free to reject it, and I certainly don't believe I'm free to argue that they should find something other than what I stipulated to. I think that would be wrong. But the case law also is that you can't bind the Commonwealth with a stipulation. They can still put in whatever other evidence they want on that topic.
Well, it's the offer to stipulate. If the Commonwealth, if you offer to stipulate, the Commonwealth isn't bound by it. Isn't that the rule?
That's the rule, but I believe that rule goes further. I cannot force the Commonwealth to abandon, by tricking them into some stipulation, any other evidence that they want to put in on that topic.
What do other states do?
Well, it's from the First Circuit's purview of other circuits and their model instructions, they come to the position that this is generally accepted to be a question of evidence, and is to be presented to the jury before closing arguments are made.
Now, going back to your last point, I mean, if it is stipulated to and the Commonwealth were to seek to offer evidence, wouldn't you expect the judge to say, we have a stipulation, Madam ADA, why are we offering evidence, and why should I allow us to spend court time to present matters that are no longer before the jury?
Well, it seems to me that the judge could do that. I'm just saying I can't stop them from doing that by saying, I stipulated to that, therefore you can't put in this evidence. A judge has the ability to say this is cumulative, this is,
Mr. Sheketoff, I'm going to make sure I understood a comment that you made just a second ago. If the First Circuit's view is that it has to go in before the matter is argued to the jury, doesn't that mean that it is, at least as a practical matter, it's in for purposes of deciding a motion for required finding?
Yes. What I think happened here is that a prosecutor simply forgot to put into evidence the stipulation. I've never seen this before, but maybe it's a common occurrence. I only get to see a part of the world. I don't, I get to see what my experience is and reading transcripts. I've never seen this before, where you reach a stipulation and the Commonwealth doesn't put it into evidence.
But when the judge later told the jury in his instructions, there was no objection to his having done so.
No.
Which could have also just sort of teed the ball, as it were, for the judge to perhaps realize that there was some kind of a problem and maybe even reconsider the RFNG.
But what's defense counsel supposed to do at the motion for required finding stage? Are you supposed to say to the judge, what you really should do is order the Commonwealth to put in that stipulation before they rest?
No, but aren't you arguing at the required finding stage that the evidence is not sufficient?
Yes.
And if the judge would like to know how the evidence is not sufficient, you need to tell the judge how the evidence is not sufficient.
Yes.
And it could be as to any of the elements.
Correct. So, I mean, if I had been trial counsel and had been arguing this, and I thought it was, prosecutors can make lots of mistakes. I don't think it's the judge's role to step down and join the prosecution team and fix these things.
Do you
I mean,
think that's
it-
really what the judge thought he was doing? I
No,
mean,
I don't think that I don't think this judge thought, and he said it because I made a motion for stay pending appeal, and he explained that, these stipulations go on all the time. This is just common practice in the district court. So for him, this is, I don't know. It's not like I had another trial with him where I saw, how he dealt with a stipulation before. I don't know if he commonly does this or it's only when a prosecutor fails to put it into evidence that he does it. I'm out of time, but can I talk about my Rule 11 issue just for a second? No? Okay.
Thank you.
Good morning, Your Honors. There is no error here. The stipulation made prior to trial, and the stipulation wasn't, and I will read it for Your Honors, the court. But is there a stipulation that the substance was cocaine? Defense counsel, yes, Your Honor. That stipulation acted as a waiver of the defendant's right to force the Commonwealth to present evidence on that topic. I suggest I would concur with my brother that there is not an abundance of definitions out there of what is a stipulation. The closest that I found was from Commonwealth versus Triplett, which says if controvertible facts are agreed to by stipulation, those facts are no longer at issue and must be accepted by the fact finder.
But they have to be presented to the fact finder in order to accept, don't they?
And they were during the jury instructions. The Commonwealth's position is that when the defendant said that he stipulated that the substance was cocaine, he waived his right to force the Commonwealth to be otherwise subject to a motion for a required finding. And this is a common waiver. It happens all the time in district court practice. It may happen pre-trial in a Rule 11 proceeding. It may happen during trial. It may happen as a matter of strategy. There might be something that comes up at trial that counsel want to avoid. And to address Justice Cordy's question about ineffective assistance of counsel, this court has has two very good cases addressing ineffective assistance of counsel in stipulations, Commonwealth versus Morgan and Commonwealth versus Housen, which stress that these are facts. This is a matter within the strategic purview of counsel that it's a very high standard that the counsel might not be manifestly unreasonable for making such a choice where he would have strategic reasons that he wouldn't want to trod this issue.
And is this the type of decision that can be made without the defendant's concurrence?
It is, Your Honor. If you look at Commonwealth versus Myers, which is an appeals court case, further appellate review was denied. It cites Commonwealth versus, it addresses this issue precisely and says this isn't the type of issue where the very small category of cases where we need a colloquy. It cites Commonwealth versus Amaral, which addressed the confrontation clause waiver on a different portion of the confrontation clause. Commonwealth also submitted a 16L letter of Commonwealth versus Lavoie, a recent decision by this court on public trial, and said that wasn't within the category of cases.
But that's not the issue, is it? I mean, I thought what Mr. Sheketoff is saying, not that counsel couldn't stipulate, it's that the stipulation needs to be put before the jury.
The Commonwealth would dispute that. The Commonwealth would say that the defendant waived his right to force the Commonwealth to put that before the jury.
Does the Massachusetts Guide to Evidence address this point about stipulations?
I don't believe that. I looked at the Massachusetts Guide to Evidence. I don't believe that it had something precisely either way. It may have addressed it in a general fashion, but I don't believe there was anything precisely on point. I can go back and look, and if there is something there, I'm happy to write a post-argument letter. I don't believe that there is. And it's important here that this is not, the defendant made a motion for required finding and made no argument whatsoever. He didn't bring this to the court's attention, and we can all think about how that would play out. You know, the defendant would say, well, Your Honor, I move for a required finding because the Commonwealth didn't prove the substance was cocaine. And I think we'd reasonably expect the judge to say, but you stipulated to that. I asked you. I mean, it shouldn't be made, so much be made on the fact that this was oral. This was a court. This was a court, question that I would say would be in the realm of an order, that it would be absurd for counsel to say, well, I know Your Honor asked me if I wanted to stipulate, and I said yes. The Commonwealth suggests that stipulate's a term of art, and people have been using it for centuries, certainly through modern criminal practice. But now I want to say that we didn't, that there wasn't enough evidence. And I'd also like to address my brother's point about agreements. Stipulations often come as an agreement per counsel to avoid what could be a very tricky issue. I think in Commonwealth versus Bizanowicz was a case where there was a stipulation as to certain CODIS evidence because the defendant had a conviction he didn't want before the jury. And to get around that issue, the parties agreed that there would be a stipulation to this issue. Again, I think if the Commonwealth had attempted to say, to not make clear when they stipulated that they were still planning on putting in evidence and then did so, I think that there would have been a problem.
In the Bizanowicz case, does the record indicate, or at least does the decision indicate, that this matter was made on the record?
Before the jury.
Before the jury.
It wasn't. It was a footnote about a greater issue on the admission of CODIS evidence.
Now, was your argument the same if the stipulation had been that if somebody were to testify, they would testify that they examined it and it was cocaine?
It is not.
Then you say that too does not need to go before the jury?
No, the Commonwealth would agree that that is a different case. Again, if you look at Commonwealth versus Triplet, there are two different types of stipulations. There are stipulations to facts and there are stipulations to testimony. And the Commonwealth would agree that the law is clear that if you just stipulate that a witness would say X, then that is not the same as stipulating that you are not contesting an element. Because the jury is free to take the witness's testimony and to evaluate that testimony or what the witness would say for its full worth as fact finders. But when there is a stipulation to an element, that is removed from the jury's consideration, and the judge properly instructed the jury as such. And again, going back to the point of whether whether the defendant was there or not, I would agree that the record doesn't speak. I think it is readily inferable that he was. The case was called to order. The parties were discussing pretrial orders. After the discussion on the stipulation, the jury is the voir dire is immediately called for impanelment. And the point is, yes, it is eminently reasonable to suggest that a defendant should say something. And it doesn't have to be out loud. In cases of stipulations, either pretrial or during trial, there is time for the defendant to say something to his counsel. No, I don't agree with this.
Is there any suggestion here that there was a conversation between defense counsel and the client before the stipulation?
Only that this was the second trial in this matter, that this trial was in December, there was a trial in September, and at that point there was a waiver of, as my brother counsel said, that the stipulation was to the admission of the certificate. And I think two points should be made. The first point is this is a case that operated in its entirety after Melendez-Diaz. So this is not a case where we're dealing with harmless error where counsel was operating under Verdi or operating under a pre-Melendez-Diaz world. Everybody was fully aware of the state of the law as it exists today.
But
And
my
the-
question is
Remind me,
whether-
did the certificate come in the second trial? No.
It did not, but that was actually Commonwealth's second point, Your Honor. This is a case where the defendant cross-examined the police witness on the certificate. So to the extent that the defendant is arguing that there was no evidence.
Sorry, I missed that. You said the certificate did come in the second trial?
It did not come in at the second trial. However,
Offered by the Commonwealth?
it was not offered by either party. However, during cross-examination of the Commonwealth's police witness, and this is at beginning at about page 51 of the December transcript, defense counsel himself questions the police witness about the drug certificate. It's not entered into evidence, but he talks about that there was a drug certificate. They talk about the bag that was analyzed was just about 0.5 gram. That the size of the bags. He talks about the purity of the bags. This witness on direct had identified conclusively, to be sure, but had said that the material was cocaine. So again, this is not a case. There was evidence, particularly through this cross-examination, which of this regarding this drugs.
I take it the cross-examination was not to establish that it might not have been cocaine, but rather to establish what? The quantity and the purity and the...
The defendant's argument at trial was that the individual who was found with the cocaine, a woman by the name of Karen McDonald, was actually the distributor. And so the drug certificate was particularly helpful because he argued it was 6 bags of cocaine, all about the same size. The defense theory was that this was just short of what's colloquially known as an 8-ball, and therefore it led more likely that she would be the distributor. Defendant does raise that on appeal. Commonwealth would like to address that. This is not a...
Could I just ask you one question? I just want to make sure I understand your argument. Your argument is, first, the fact that the stipulation wasn't put in evidence doesn't matter. The stipulation was a stipulation and it's binding.
Yes.
But are you also saying even if it would matter, because there was no objection, as you said, it wasn't raised, it required finding him not guilty, et cetera, you could never say there was a substantial risk of a miscarriage of justice? Is that
the Commonwealth is saying that there is, it wasn't raised at trial, that this is, the failure to enter the stipulation would be a matter of evidence and not a matter of sufficiency, that it should have been raised, that it was not raised, that there was ever evidence available, that this should be that there is no reversible error. And if you look at the Pratt case, which defendant heavily relies on, they found that there was no plain error. The 2-to-1, the majority and the concurrence disagreed about, they all agreed there was no settled rule on how a stipulation should come in. But the majority did say there is a settled rule that it should be presented to the jury. They relied on pattern instruction through the circuits, not all which were the same. But even given that point, and this is a matter of federal practice, not a matter of any constitutional law, the Commonwealth would suggest, they said that this was a technical error that didn't remotely rise to a plain error, which is the default standard in the federal government. And they cite cases which say that while it might be better practice to put it before the jury, it certainly isn't a type of error that would reverse a defendant's conviction. And to the extent that there may have been some confusion, the Commonwealth did submit a letter on the procedural status of the Pratt case. Cert was granted in that case on a different ground. It was returned to the First Circuit, who 2 years later, and that is cited in the Commonwealth's letter, kept the parts about the stipulation and the concurrence unchanged. So the words, as to the extent that they are relevant in this case, and the Commonwealth suggests that it's relevant only to show that it's not plain error, is good law. However, the Commonwealth suggests that it shouldn't affect your view of how the long-standing Superior and District Court practice that stipulations come in as a matter of agreement with counsel, with the judge, and may be done in a number of ways. They may be done pre-trial.
But there's no law that says that really approves of doing it the way it was done here.
Correct, and I suggest there is no law to the contrary either, Your
Right,
Honor.
but so that's why it's here.
That's precisely why it's here, Your Honor. And
Can I just follow up on that point? Are you saying basically that it should be judged under a substantial risk of a miscarriage of justice standard? Error, should it be viewed as under the substantial risk test?
where it was never raised at trial and where he's claiming that there was an error at trial. Yes. It should be
yes is your answer?
Yes is my
Yeah,
answer.
okay. Is there other evidence here? You said there was this cross-examination that took place. We'll look at the totality of the record.
Right.
Was the testimony of the officer that the napkin contained cocaine enough to establish anything?
I suggest in conjunction with the cross-examination that made it clear that the lab examined the drugs, that talked about the purity of the drugs, that talked about the weights of the drugs. Those two things in conjunction are enough to prevent any error, which the Commonwealth suggests did not occur, from being reversible error.
Your
Thank
time
you, Your
is
Honor.
up.
Thank you.